Your Honor, today we will hear the case of Jackson Public School District versus Carter. My name is Micah Robinson, and I am representing Tina Carter. The principal of Jackson High School wrongfully prevented the formation of a student group. This is a direct violation of the Equal Access Act of 1984, which states, all schools that receive federal money and grant an offering of or an opportunity for non-curriculum related student groups must provide equal access to all student groups, regardless of the group's focus or interest. Since the school allows other extracurricular clubs, such as service and religious clubs, the LGBT+ Alliance must be allowed a position as a school club, without any regard to the subject. The club should be treated like any other extracurricular and given equal resources, such as a sponsor and a location to have meetings. If the issue was that Carter did not go through the correct channels to start a club, then there would be no case. Instead, Carter's request was denied. She went through the chain of command and was denied access to secure the opportunity to form a club. There was no legal reasoning for this. Instead, the principal denied Carter's request due to bias, which is again in violation of the Equal Access Act, an act protected by the First Amendment. Previous cases defend my client's claim that the denial of the formation of a student group is unconstitutional. Westside School District versus Morgans established that the Equal Access Act is supported by the First Amendment Establishment Clause. Its decision explains that as long as students have the choice to be exposed to the practices of a student group, then the club cannot be denied. Because the Equal Access Act is a matter of student freedom of speech and assembling, Tinker v. Des Moines Independent School District's disruption test holds merit in this case. As an extracurricular club, the meetings are optional for students and outside of class time, which rules out any argument for coercion or disruption. From the Supreme Court's decision of both cases, the Supreme Court being the overseers of the highest law of the land, which governs all of us, the jury now must vote in favor of Carter. The weak power of a school board does not overrule the Constitution or the Supreme Court's previous decisions. This club is protected by law to have equal opportunity to be formed, and a principal cannot stop that regardless of personal bias. I rest my case. Okay, now that one should work. If it doesn't,